It's a matter of fact. We must have seen. So therefore, don't we think that for upholding the rule of law, we will have to pass a resolution saying that for a period of 5 years, the judge who has stepped down from the judicial post should not be considered for granting the status of designated advocate under the Advocate Act? Very small issues. All these issues are going to ultimately uphold the rule of law. See, the judge's appointment is one facet. Appointment of a judge or transfer of a judge of Honorable High Court or the Supreme Court is one of the facets. Unfortunately, what is told in the bar room, in the corridors of the respective courts, once you become a judge of a High Court or the Honorable Supreme Court, you become Amar, you become immortal, because there is practically no, it is impossible to remove that gentleman from the judicial post. And now as a result of that, what is happening? Now the other things are coming automatically. In our Bombay High Court, I am practicing at Bombay High Court, there is one corner where some advocates sit regularly. And that corner is known as DRT corner. DRT corner means dismissed, removed or terminated from the subordinate judiciary. And now question comes whether we should encourage litigants to instruct or to brief those DRT judges. We'll have to say, sorry, don't go to that gentleman. He may be good at law. He may be having extraordinary background. He might have been selected for the purpose of, he might have been appointed as a judge. But since he has resigned, don't entrust a brief to him. Otherwise, there is a danger to the rule of law. Consider this. These are the practical problems which are faced in all courts. Now, I'll give you one or two more examples. Now, an opinion of a retired judge of the Supreme Court or the retired Chief Justice, we know how these opinions are manipulated, how these opinions are used in other proceedings to influence the judge before whom those opinions are cited. I am sure some of us might have tried that also. Don't you think that there has to be a clause somewhere in writing saying that those opinions whosoever the Honorable Retired Judge expresses in writing should not be placed in any judicial proceeding? Ultimately, what is this? This is again trying to influence the another learned judge by pointing out what the learned senior judge has opined. These are the practical issues. I believe we will have to consider these small issues so that there can be upholding of the rule of law. I agree with Prashant Bhushan what he said. He said that there has to be an independence of judiciary, but there cannot be independence from the accountability. I fully agree. Let us try to understand. Are we expecting a watertight compartment between legislative, executive and judiciary? As a student of law, I believe it is impossible. And therefore, if the Constitution has come with a particular type of framework which says that check and balance, then obviously we can't expect absolute independence. This is like somebody is controlling another is controlling the first one is controlling second is controlling the third. Now, as a result of that, if this is a framework of the Constitution, we can't claim any absolute independence. And now, therefore, the question is, what independence we are thinking? With connection with the rule of law. Obviously, we are thinking about that kind of line which is popularly known as Lakshman Rekha. We are expecting that those all authorities should stay within the framework of Constitution itself. Otherwise, that will be a failure of the entire mechanism. I believe the conclusion of these two sessions should be on this note, that everybody should stay within the framework of the Constitution. They should stay within their limit. Otherwise, I am apprehending that it will be a complete failure of the system. Let us go back. theory of separation of power is already there in the constitution, but I am afraid there can't be an absolute separation. And as a result of that, even today, for small things, judiciary is required to depend on other so many agencies. I'll give one or two examples. Let us ask a question to ourselves. We are coming from entire India. Let us ask a question to ourselves whether the building in your part where that court is to be housed, whether that is sufficient. The answer will be no. Then obviously question will come for getting the plan sanctioned or for the purpose of construction, the judiciary is depending on the other wings. So therefore, we can't say that there has to be absolute independence. Let us consider also one more aspect. The statistic will show that a marginal amount is provided for the purpose of judiciary in the budget. As a result of that, there is nothing like a separate budget for judiciary, a marginal amount is there. So therefore, we will have to depend on the legislature, because legislature is going to pass that particular proposal for the purpose of whatever the bill for the purpose of expenditure on the judiciary. I will give one or two small examples. Take a case with reference to the salary or the honorarium of a judges. Last week, I was handling one case before the Honorable High Court. Obviously, it was a public interest litigation. In Maharashtra, members of the Consumer Dispute Redressal Forum established under the Consumer Protection Act gets a remuneration of rupees 400. It was brought to the notice of the Honorable High Court. High Court was shocked. We placed it on record that in 2011 as well as in 2012 a resolution is already passed saying that give them a pay scale equivalent to the under secretary. Why it has not been implemented? Even today they are getting rupees 400 as a remuneration per sitting. Per sitting 400. Now I am sure if we are considering about the upholding the rule of law, then there has to be a corresponding duty on the other two agencies that the judges should get adequate salary and the remuneration perquisites. Shetty Commission has brought a substantial change in the salary pattern, but the judges of the family court, they are not included under that. As a result of that, our High Court, Bombay High Court, was required to deliver a judgment in the month of July saying that Shetty Commission recommendations are made applicable to the judges of the family court. Now there are so many such examples. A learned judge of the Honorable High Court came before the Honorable High Court as a petitioner saying that, sir, my pension which has been granted to me, that is not fixed correctly. Look at the situation. One of the learned judge of the Honorable Bombay High Court was required to file a petition when he was transferred at Jaipur, and the petition was filed there. Now these are the small issues which are coming up, and obviously we will have to support them. Otherwise, there will be again question with reference to the rule of law. Let us go back. And now the question comes, what the advocates can do. And that will be a last point of my sharing of the thoughts. Obviously, we are one of the stakeholder who can be called as the largest stakeholder in this entire administration system. As a result of that, we will have to ask some question to ourselves. What we can do for upholding the independence of judiciary as well as for upholding the rule of law. 2-3 points which are coming up in my mind. Obviously, that is not a complete list in itself. There can be so many other opinions which are possible. We can become a pressure group. We can also try to become a watchdog. I'll give one example which happened in Bombay Honorable High Court. 1991, I'm sure Anil Divan must have shared that on so many occasions. We passed a resolution, our bar passed a resolution boycotting 4 judges, saying that we will not appear before those judges. And ultimately the truth was found to be correct, and some of the judges were required to tender their resignation, some were transferred, and ultimately the bar won that battle. This is 1991 Bombay examples. There may be other examples in the state of Maharashtra. Absolutely correct. Absolutely correct. Justice Bhattacharya was the one of the person who was in that list. Now, let us go back. We are having a right to criticize. We as a lawyer are having a right to criticize. As a layman, while sitting at Mumbai, we quite see that Prashant Bhushan, how can he say so on the media? And I'm sure some of us might have, the thought must have come in my mind, don't you think that he is walking on a tightrope? I believe as a member of a Bar Association of India, we are having a right to criticize, right to comment, right to discuss, right to deliberate, even on judgments, even on conduct, obviously within the four corners of the Constitution. And now therefore question comes that what we can do. I think this is a second session which is going to pass a message to every participant who is going to carry this message for upholding independence of judiciary. We as an advocate, we are also stakeholder. We will have to be vigilant. We will have to become watchdog. We will have to discuss these various issues at our respective bar throughout the India. And I believe that will be one more positive step towards upholding the rule of law. Thank you very much. Thanks a lot.
Thank you, Varanjika. You have raised many questions which I have noted down. Case law and face law, uncle judges and auntie judges, retired judges, giving opinions, stakeholders, etc. I think we have to discuss this. DRT reminds me of some banking tribunal where DRT cases are done. So he has raised a lot of questions. But now, I would make a very small request to him. I notice that he is a member of the Bar Council of Maharashtra. I think that's the body where many of these questions can be discussed and enforced. Because the Bar Council is a statutory body, we are only a voluntary association. What we can do, and we have been doing, is to write articles, go for discussions, and raise public opinion. But the Bar Council is a place where they can pass resolutions, make rules, etc., not only for judges, but also for members of the bar, because that's very important. So I thank him once more for a very stimulating address. And with this, I think, would you like to say something? Vote of thanks? You must thank me, I say.
Friends, we are ending this session with the thanks to the chair, Mr. Anil Divan, Prashant Bhushan, Upul Jayasuriya, and Uday Varunjikar. We are starting the next session very soon right now. Thank you.